When we talk about estate planning, there are really three documents that are the cornerstone of any good plan: the will, power of attorney, and a healthcare directive. Wills take effect when you pass away, but the other two documents, powers of attorney and healthcare directives, come into effect when you lose capacity to make decisions on your own. This presentation will deal with powers of attorney. Please note that the information shared in this presentation is very general in nature, and we encourage you to discuss your specific circumstance with your lawyers and to get proper advice. So, what is a power of attorney? A power of attorney document is a legal document in which a person, called the donor, gives the authority to another person, the attorney, to make decisions regarding some or all of their financial and legal affairs. To clarify, the word attorney in Canada means someone who's appointed under a power of attorney document. The term is different in the US. In the US, attorney refers to a lawyer, so that's often confused. But in this presentation, when we talk about an attorney, we're not talking about your lawyer, we're talking about the person that you've named to make financial and legal decisions for you. There are different types of powers of attorney that you can make in Manitoba. Some come into effect immediately. Others are what we call springing, which means that they give the authority upon a certain event, such as when you lose capacity. Some have specific purposes, such as dealing with the sale of a house, would be an example, and some are general in nature. And some are enduring and some are not. Enduring means that the power of attorney continues to be in effect if the donor loses capacity. So when we're talking about estate planning and incapacity planning, really the document that is most often made is a general enduring power of attorney, which means it is general in scope and is and continues to be in effect in case of capacity, loss of capacity. It's a very powerful document, and therefore it requires certain professionals to witness the documents in order to ensure that the person signing it has the capacity required to sign it and they're not under any undue influence. Most of the time, that person is a lawyer. In order to make a power of attorney document, the donor must be mentally competent to do so, and that's a legal test which is specific to making powers of attorney. The power of attorney document must be in writing, and it must be signed and properly witnessed. Now, why would anyone want to make a power of attorney document? Well, first of all, it allows the person to choose who will manage their affairs, their property and their financial affairs for a period in which they are very vulnerable and not able to make decisions on their own. It helps to plan for a time when they're not able to make decisions on their own, and it provides the peace of mind of knowing that the person that you've named will be the one managing your affairs for you. It also avoids the time and expenses of a committee application. So that's a big word. What does that mean? So there's a law in Manitoba that says who can make financial decisions for you if you haven't made a power of attorney document, and it entails an application to the court. So a person can apply to the court for the right to make financial decisions for you. In order for that to happen, you have to be not competent to make a power of attorney document, and the court process is lengthy, and it requires that the person applying, they're called a committee, the person applying will be the one that will make financial decisions for you going forward, and it is required to pass their accounts to court on a regular basis. Usually that's annually or semi-annually. So the whole court application and the passing of accounts at court can become very costly, and it can be avoided by preparing a proper power of attorney document. In addition to that, by making the power of attorney document yourself, you are able to select who will be making financial decisions for you. If someone makes a committee application for you because you don't have a power of attorney document in place, that person may not be the person that you would have otherwise selected. When preparing a power of attorney document, it's very important to consider who is the proper person to name as your attorney. So the person selected should be a person that you trust will make good financial decisions for you in your best interest. So many clients ask me, well, do they have to be in Manitoba? Should I name my eldest son, my eldest daughter? What if somebody is insulted if they're not named as attorney? So first of all, what you're doing is you're giving someone a job that is difficult, that entails a lot of financial responsibility. Some people think that it might be an honor to be named as attorney because it shows trust, but at the same time, you're essentially giving someone a very difficult job that is very often underpaid or not paid. So it's something to consider when you're naming the person that will make financial decisions for you. The other thing is, though it is sometimes practical to name someone who is close to you physically, so that is in Manitoba, it's not necessary. The most important thing is that the person that you name will always act in your best interest and put your best interest ahead of their own. It's possible to name more than one attorney, so if you want to name two people together, that's fine. The benefit of having more than one person as attorney is that there are some checks and balances. There's always two people or three people or whatever you decide that make decisions together. The disadvantage is that it's more cumbersome. They always need to be together to make decisions, so they would need to go to the bank together, sign legal documents together, things like that. So it's a discussion you should really have with your lawyer as to what makes sense in your situation. The power of attorney document can specify whether an attorney should be paid or not paid. If the power of attorney document is silent, then the court would have the ability to make a determination as to what is fair and reasonable compensation for the attorney. In your power of attorney document, you can also decide how broad or limited you want your document to be. So some people think that a power of attorney document is something, a legal form of some kind that's always the same. That's not the case. Every power of attorney document is different and is drafted by your lawyers based on their own experience or on documents that they've had passed down to them from other lawyers, and it has been finessed over time. So there is no standard power of attorney document in Manitoba. Essentially, the power of attorney document allows the attorney to do anything that the power of attorney document says they can do. And often these documents are very lengthy because lawyers try to ensure that there's everything in there, that there won't be a circumstance that we've missed where the attorney then has to apply to court for the right to do X or Y. Having said that, if there are specific things that you want your attorney to be able to do that are not generally interpreted as being in your best interest, it's important to put them in your document. For example, if you want your attorney to be able to use your money to support a dependent child, or just someone that you've been supporting financially, it's important to put it in the document. The same goes if you're making donations to the church or to any other charitable organization and you would like that to continue if you lose capacity, that needs to be in your power of attorney document. Same thing if you're always making birthday gifts or Christmas presents to children and grandchildren and you want that to continue provided that you have enough money and that it's reasonable to do so, that should be in your power of attorney document as well. So who should prepare a power of attorney? In my opinion, any adult that is competent to make a power of attorney document should make one. We all are at risk of losing capacity. It's not something that we plan on doing, but it's something that often comes up. And once we lose capacity, it's not possible to go back and do a power of attorney document. So it's important to plan ahead. Without a power of attorney document, an application for commenteship may be necessary, and the person who will apply, as I indicated earlier, may not be the person that you hoped would manage your finances. The cost of not having a power of attorney is much higher. So if a commenteship application is required, the cost of doing that is significantly higher than the cost of getting a power of attorney document properly prepared. If you don't have a power of attorney document, it may be months and months before someone is able or is appointed by the court to be able to make financial decisions for you. In my practice as an estate lawyer, I have found that having a power of attorney in place is as important, if not more important, than having a will in place. And that is because it takes effect while you're alive and really affects your life. Whereas a will, if you don't have a will, there is a law that says who benefits from your estate. And that law is sometimes sufficient for most people. But by not having a power of attorney document in place, your loved ones are stuck in a very difficult situation where they're trying to care for you, for your finances, and are limited in their ability to help you. So you've been responsible, you've gone out, you've seen a lawyer, you've had a power of attorney document prepared, and now what do? It's very, very important that you let your attorney, the person that you've named as your attorney, know where they can find the original document and that they've been named as your attorney. If they don't know that they've been named as your attorney, or if they don't know where to find your document, it is very likely that they will not be able to find it or that they will not look for it. And if that's the case, then a commenteship application would become necessary. So it's very important that they be able to find the original document, because they can only act with the original document or notarial copies of that original document. Power of attorney documents are very powerful. They give someone else the ability and the control over all of your financial and legal affairs if you are incompetent. And so it's very, very important to ensure that the person that you name is someone that you trust, that they can find the documents when they need to, and that they are aware of their obligations to act in your best interest. I hope this information has been useful to you, and I thank you for participating in this video.